2 of the Constitution, Article 73 of the Constitution, Article 81, E, Roman 2 of the Constitution, and Article 152 of the Constitution. 152, sub-article 3A of the Constitution. I therefore invite my lords to make a finding that that provision in the Leadership and Integrity Act, specifically Section 23, which the third respondent has cited in paragraph 27G of his reply affidavit, is contrary to the Constitution and should be declared null and void. Right? I'm saying so because of the provisions of Article 2(1) of this Constitution, which says that the Constitution is the supreme law of the Republic and binds all persons and all state organs at both levels of government. And some Article 4, any law that is inconsistent with this Constitution is void to the extent of the inconsistency. Now, my Lord, there is one area I want to submit on that directly touches on the third respondent himself. My Lord, Article 84 of the Constitution states that in every election, all candidates and political parties shall comply with a code of conduct prescribed by the Independent Electoral and Boundaries Commission. And I want to emphasize, my lords, that the word used is shall, meaning the requirement is mandatory. Now, pursuant to that article of the Constitution, the first respondent released a code of conduct which can be found in the second schedule of the. It says the object of this code is to promote condition that is conducive to free and fair elections in a climate of tolerance in which political activity may take place without fear, coercion, intimidation, or threats of reprisals. That's what the code states. Further, it says in Rule 5 that all candidates must adhere to the values and principles of the Constitution. D, they must condemn and avoid intimidation. Rule 6B, it says they must refrain from involving in any act of intimidation. My Lord, we want to submit that the evidence I'm about to place before the court demonstrates a case where the third respondent went contrary to this code and by extension violated Article 84 of the Constitution. I want to refer, my lords, to page 41. My Lord, there's a quotation there from the third respondent when he was touring, I believe that should be Makueni. That's 1.27. And My Lord, what I'm about to read is a clear case where innocent citizens were intimidated with some threats from the third respondent. And this is what he says. Tutaonana na nyinyi baada ya uchaguzi. Tunaelewana wazee. Whom it's alleged had shown support or inclination towards a candidate other than the third respondent. And my lords, what I've read to court is what should manage an election that should meet the standards of a free and fair election, that meets the standards of Article 81, Sub-Article E, Roman 2, free from intimidation or an improper influence. On this area, my lords, you don't need to look at numbers. If the Constitution was violated, if laws that are supposed to guide our conduct during elections were violated, it matters not whether you have a massive lead. The question is that the law has been violated, and this honorable court should be invited to vitiate such an election. And my lord, I dare submit that this court and other courts have shown seriousness when dealing with issues where there is violation of any law dealing with the elections. My lord, I want to refer to the case of Masika versus Combo, which is at page 56. That quotation is at page 56 of our submission. And my lord, this is a case where, my Lord Chief Justice, you are the presiding judge. And this is the ratio that was laid down by that court. And this is what, I just want to make a small quotation. For instance, no election can be valid if it is not based on the principles of universal suffrage, if it's not by secret ballot, if it's not transparent, free from intimidation, improper influence, or corruption. You know, those are the standards that the courts have laid down on issues dealing with free and fair election. It's not about numbers. It's whether the Constitution and the laws governing elections have been adhered to or have been violated. So in this particular point, my lords, you don't need to look at numbers. And my lord, there is another case that the learned judge Lenaola dealt with. I think at page 63 of our submissions, paragraph 199. This is the case of Charles Omanga versus Independent Electoral Commission. And the learned judge of the Supreme Court sounded a warning on this issue. This is what Justice Lenaola said in that decision. Let this judgment sound as a preparatory song to them. They cannot have one leg in public service and another at their elective arena. What the judge was emphasizing is the simple fact that in an election, those who are in public service make a choice to serve the people of Kenya without any discrimination at all. And they must at all times show neutrality. The same jurisprudence was expounded in the case of Hatib Abdallah Mwashetani versus Gideon Mwangangi Wambua. It's at page 65 of our written submission. And my lords, in that particular decision, the court said that the issue of improper influence is a new concept introduced by the new constitution that has a wider concept than undue influence. So my lord, this issue of ensuring that there is no improper influence in election is a concept that was introduced by the new constitution of 2010. And my lord, the only branch that can assert the supremacy of our Constitution, the importance of Chapter 6 of the Constitution, is the Supreme Court. And I invite my lords to come out strongly on this and make a finding that these cabinet secretaries and the third respondent violated important principles that are in our Constitution. Now, as I sum up my submissions, my lord, I want to address my lords on the issue of standard of proof on this issue. Lord, I want to submit that this court should have two approaches on this issue. Two approaches. Lord, the first approach should be on a balance of probability. My lord, on this one, if on a balance of probability, the petitioner can demonstrate, as he has done, that the Constitution and the laws dealing with the conduct of candidates during elections were violated, this court should void the entire election. So on voiding and nullifying the elections, the standard should be on a balance of probabilities. When it comes to the second angle, that is tying. I will. Yes, my learned colleagues will be submitting on those authorities.
When you come to the presentation of the law, we have the list of authorities.
I thought there was one on this particular point with the VPD.
I will deal with the submissions of that.
There will be a number of authorities my learned friend will bring to the attention of the court. Now, the second one, my lord, that should be beyond reasonable doubt should be the one dealing with Section 14 of the Election Offences Act. And on this one, my lord, I can make one reference to a case that is at page 53 on this issue, that for this court to make a finding that an election offense was committed, then the standard should be beyond reasonable doubt. But for purposes of voiding the election, nullifying the election, it should be on a balance of probabilities. I'm making reference to a decision that is at page 53 of our submissions. At paragraph 166 of our submissions. And my lord, the standard that has been laid in that case is that in cases of bribery, then the standard should be slightly higher than on a balance of probabilities. The case is Judicial Committee versus Ringadu and others. It's at paragraph 166. So, my lord, in conclusion, it's our very humble submission that the evidence that has not been rebutted that is before the court proves that there was violation of the Constitution and the various electoral laws that should invite this court to vitiate the election that was conducted on the 8th of August 2017. Lord, in conclusion, there is one issue that is outside the realm of this petition, but which I invite this court to consider as it makes its final judgment, and that's a proposal on some constitutional reforms on the issue of presidential petition. Lord, the 7 days that are allocated to a petitioner to file a petition, considering that we are dealing with more than 40,000 polling stations, is not adequate. And the period of 14 days within which the court must hear the petitioners and the respondents and make a finding is also not adequate. I invite your lordships, in your judgment, to make a strong recommendation for some reforms on the timelines on dealing with presidential petitions. Thank you. Pardon me? Sorry. I'm up, my lords. You know, my lords, I've since learned something called tyranny of numbers. But this court can act as... thank you.
Mr. Mogeni,
Yes, my lord.
I really had hoped that one day I will have an opportunity to speak in court. I didn't know how I would get the opportunity. But now that you have opened up that angle, I wanted to remind you that the president of this court, who is the Chief Justice, was the chairman of the Judiciary Working Committee on Elections. And before that, I was for 5 years. And we made a concerted effort. I will summarize, I know there's time issue. We made a concerted effort to persuade. In fact, I was for 45 days, but I was shot down to 30 days. And finally, we ended up in Parliament, and who are the chairman of that special committee? It was two chairmen, Honorable Orengo and Kiraitu. And we thought we had persuaded them. I don't know where the bill went. So there you are.
Yes, thank you. I'm just borrowing from the Ghanaian decision that strongly recommended on some, legislative reforms on issues dealing with presidential elections. And I thought maybe this court can borrow a leaf. Thank you, my lords.
Very well, we have noted that. So, but as I said, you are in a better forum.
My lords, the views of the court through the president in the Senate, I know is on record as part of the record of the Senate and the National Assembly. So I hope that the challenge given to Senator Okongo Mogeni will be taken up and we will support him. Now we have my learned friend Mr. Paul Mwangi, who will deal with some legal issues, constitutional and legal issues, and authorities.
Yes, my Lord Chief Justice, my Lady Deputy Chief Justice, my ladies, my lords, I will be discussing the legal issues that arise from this petition. And my Lord, okay. My Lord, I want first to submit that in very many ways this petition is not the same as what was before you in 2013. The court is the same, the parties are the same, the dispute is the same. In fact, as we'll see later, the mistakes are the same, but the legal regime is different. And I want to give 3 instances how the legal regime in this matter has changed since 2013. But one of the disputes that was before you in 2013 was the issue of voter registration. And the issue then, as raised by the petitioner, was that the IEBC had adopted a computer-based biometric voter registration system so as to allow a quick and precise identification of voters and prevent fraud. The case that was pleaded to you by IEBC was that the BVR system was not meant to replace the legally required manual voting system and was only meant to provide an added layer of efficiency and integrity. This court, in 3 paragraphs held, in paragraph 248 of the judgment, Raila versus IEBC 2013, it says, we must conclude that such a register is not a single document, but an amalgam of several parts. Secondly, in paragraph 249, it said the multiplicity of the register is a reality in Kenya voter registration system, which is recognized in law and largely acknowledged in practice. And in paragraph 256, this court held that although we find that there were many irregularities in the data and information captured, they were not substantial to affect the credibility of the election process. But Lord, between the last 5 years, the petitioners in this matter lobbied to change the law, successfully having passed the Election Laws Amendment Act number 36 of 2016. And I'm not just giving them credit, it is actually DuPont 2 in the affidavit of in the affidavit of the 3rd respondent, which is the affidavit of Gushu. I'll get to it, and in which they say that a lot of these reforms came up because the petitioners demanded for these reforms. I will get the paragraph just now. What happened is that when the law was passed, the legal regime changed. They amended Section 2 and removed the reference of the principal register to provide for a register of voters. Then the register became one document. They provided for biometric data. They provided for an integrated electronic system. They provided for inspection of the register, its posting on a public portal, auditing of the register. And my point is that your lords will notice that the issue of the register is not in question in this petition, which testifies to the changes that have happened since 2013. A second issue that came up in 2013 was the issue of use of technology. And the issue then was, the petitioner's case was that IEBC had failed in the system that it had set up to identify voters and transmit results. And the petitioner's case then was that without any electronic processes, there was no base for verification of the results. The IEBC's case then was that there was no requirement in the Constitution and the law to establish and conduct an electronic electoral system process, and that the voting, counting, tallying, and transmitting of final results were required and designed by the law to be manual processes. The court then agreed with IEBC and stated in paragraph 131 that an objective reading of the regulations does not reveal a contemplation of elections conducted solely by electronic means. And it says that the elections of 4th March 2013 were not envisaged to be conducted on an entirely electronic basis. In paragraph 133, the court said that most polling stations in Kenya are in the rural areas and supply of electricity is a distant dream. And in paragraph 237, the court said that it is not surprising that the applicable laws entrusted a discretion on IEBC. Again, the petitioners managed to lobby for the passing of reforms, again, in Election Laws Amendment Act number 36 of 2016. And in section 14(1)(c) of that act, they amended section 39 of the act and provided for an electronic transmission of election results for presidential elections. In paragraph 17, they removed the section 44 that was in the law then, which section 44 had given IEBC a discretion in respect of the use of technology. And it now became mandatory for IEBC to use technology. And the law actually itself sets up that electronic integrated system for purposes of identifying voters and transmitting of results. The law even went further and created a legal regime around the technology, setting up the principles for use of technology, and passing the elections, requiring IEBC to make rules, which were made in the form of Election Technology Regulations 2017. My lords, the Parliament later were to amend this law and pass a section 44A that allowed a complementary system for identification of voters and for transmitting results. There is no allegation I've met yet from the first and second respondent that this was ever resorted to. So the legal regime as we are dealing now is that in terms of identification of voters and transmission of results, this election was purely electronic. Now, in the, again, in the affidavit of Gushu that I referred to, there is an annexure, which is in the form of a statement that was issued by Chebukati. And again, I will read that in a moment. And in that annexure, the chairman, in a briefing of the same day, stated that the KIMS system, which is the integrated integrated electronic system, was working fine, and that there were no problems, and that even in the instances where identification by BVR had failed, they had been able to resort to what they called a numerical system by which voters were being identified using an ID. That will be important to this court when considering about the failures that were later to come in this election. The third issue, my lord, was in respect to the dispute about what were considered to be malpractices at the National Tallying Center. And the issue at that point was that the petitioner case was that its agent had been removed from the tallying hall while they were witnessing the tallying. The IEBC's case had been that the agents of the petitioners had become rowdy and quarrelsome and had engaged IEBC with paralyzing confrontations. The court agreed with IEBC. It said that IEBC had an obligation to resolve any kind of impasse and properly exercised its discretion in moving the agents of the petitioner from the tallying hall. Now, the petitioners, again, lobbied for the change of the law, and the law created a public portal for the display of results that was announced at polling station. And the purpose of this amendment was to get rid of this issue of agents being thrown out of the National Tallying Center. And the significance of this, my lord, is that the portal therefore became the system of transparency in respect of the tallying of results. It became the new system of accountability, and its function must therefore be looked at from that perspective. My lord, if I may go back to the affidavit I'd referred to, this was the affidavit of the third respondent's affidavit by Winifred Washake Goshu in respect of the first petitioners and Dr. Nyangasi Aduo's affidavit. The two references in paragraph 17C, she says, as a result of the aforesaid demonstrations, political parties, she's referring to demonstrations made by the petitioners and their supporters. Political parties were forced to initiate a bipartisan effort to address the grievances put forward by CORD. She says on the 5th of July 2016, the Senate and National Assembly approved a motion that established a joint parliamentary select committee. Now, in respect of the statement by, there's a statement by Chebukati issued on August 8th. The page I have is not properly paginated, my lord. I think it is page 25. But what it reads is as follows. We are aware of reports that in some cases the identification took longer than expected, while some officers had challenges switching on their KIMS kits. Our clerks have been instructed to use alphanumeric identification where the key in the voter ID number, where they key in the voter ID number into the IBC platform to confirm registration. We are also replacing some of those KIMS kits. On the next page, it says, we would like to assure you that our officers have been deployed to resolve the technical issues. Some of the areas where we have deployed extra ICT support staff includes Wajir, Isiolo, Dadaab, Fafi, Borabu. My point, my lord, is that pending the reports that will come tomorrow, any failure or any lack of function of the KIMS kits is only a matter of impunity. There was no failure of technology in this election. And the second point to note is that technology was an essential part of the transparency of this election. My Lord, I want to come to the first legal issue arising. I want to raise two legal issues that arise from the judgment of 2013. The first one is in respect of Section 83 of the Elections Act. And we are submitting to this court that you need to review the position that this court took in the 2013 decision. And according to the section, an election will not be invalidated by virtue of non-observance of the Elections Act. Let me read as it reads. That no election shall be declared to be void by reason of non-compliance with any written law regarding to that election, if it appears that the election was conducted in accordance with the principles laid down in the Constitution or in that written law, or that non-compliance did not affect the result of that election. I first wish to begin, my lords, by saying that although 2013 seemed to change the legal position, the statement that is made in the judgment of 2013 actually appears to have been made by incurium. When the court was making that statement that has now been construed to mean that this court meant that you must satisfy two limbs, in fact, the court was involved in a discussion regarding burden of proof. And after discussing the issue of burden of proof, in paragraph 196 is when the court says, we find in such a judicial approach as it is exemplified in several cases from Nigeria, where a party alleges non-conformity with the electoral law, the petitioner must not only prove that there has been non-compliance with the law, but that such failure of compliance did affect the validity. The court did not analyze any of the laws regarding Section 83. It began first by looking at the case of Morgan and others versus Simpson, which is in paragraph 178. It did not make any other reference to any of the cases that have been decided on this point. And the only next mention is made in 196. So my first submission, my lords, is that whatever is deemed in the 2013 decision to have been a statement of law was actually a statement that was made by incurium. But the first question we ask is Section 83 creating one rule or two? And that depends on the word or. Because in the judgment of the court used the word and. But the word and used by the court is not taken from the statute. It is a word that was inserted by the court itself. If you use the word and, then it becomes one rule. And by this rule, then, a petitioner would not only have to prove compliance with the Constitution, non-compliance with the Constitution, but also prove that there was an effect on the results. And it shall submit later how absurd that result would be. What the section does, it uses the word or. And the interpretations that have come to that is that there are two ways in which an election can be invalidated. One, if it doesn't comply with the principles of the Constitution. Or secondly, if as a result of that non-compliance, it has affected the results. Now, my lords, one of the absurdities that arises from using the word and is to mean that even if there is a transgression of the Constitution, that this court can still allow an election result to stand on the basis that it did not affect the result. Our submission is that that would be undermining the supremacy of the Constitution. If a court could actually allow a contravention to stand on the basis that the result is not determinable. And that would go against Section 2, Article 2, which voids anything, any law, even customary, any act, any omission that contravenes the Constitution. And for that reason, it cannot be interpreted to mean that when a party shows and displays and proves to the court that the constitutional principles have been derogated, that that party would still then be required by the court to go further and show how that contravention of the Constitution affected the results of that election. Our submission is that once a contravention of the Constitution is proved, the matter ends there, and that act or that election is invalidated. I shall later come to the authorities that have been decided on that point by various judges of this judiciary. But my lords, we have in our submissions also given instances of when the word "and" is used. And first, in the case of Morgan versus Simpson, which is quoted in the decision of 2013, the court was dealing with the Representation of People's Act 1949 of England. And it is in that case that the word "or" is used. Therefore, in interpreting the effect of the word "or," one would have to look at the Morgan case and any other cases that would have been decided along the trail. And the Representation of People's Act was not dealing, it was dealing with local government elections. However, there was another act that one sees in the authorities, which is the 1872 English Ballot Act. The 1872 English Ballot Act uses the word "and." This act was the first UK legislation to deal with this issue. It dealt with parliamentary elections, so that you had a dichotomy. When it came to parliamentary elections, the law in England said "and." When it came to local government elections, the law in England said "or." I was not able to trace authorities that flowed from the English Ballot Act, but that position was then later codified. But the point is that we must follow the line of authorities that are based on a statute that used the word "or." And with that reason, then Morgan versus Simpson becomes the authority to follow and the authority that should have been adopted. The 2013 court did deal with Morgan versus Simpson, but only mentioned it, but noted what it said and mentioned it, but never went into any further discussion on its effect. And we are inviting this court to start that discussion in this judgment. My Lord, I will come to the effect of that non-observance as indicated in the authorities. The first is what is stated in the case of Joho versus Nyange, which, my Lord Justice Maraga, Chief Justice, you decided. It's a 2008 case. And very telling is that this case was decided before even the new constitution came in. And what my Lord said was that the law is clear as to when an election can be nullified. An election will be nullified if it is not conducted substantially in accordance with the law. It will be nullified even though conducted substantially in the law if there are errors, mistakes, however trivial, which are found to affect the results of the election. Again, there was a dual, your Lordship used the dual standard, in which emanates from the word "or." But at this time, your Lordship was dealing with Section 28 of the National Assembly and Presidential Elections Act. And in that act and the constitutional regime that was there then. The constitutional regime was not as specific as today, because it is in the current constitution that we have very clearly spelled out constitutional principles in respect of elections. But even when those principles had not been spelled out, the law still was that the dichotomy rule was used. My Lord Chief Justice, again, in Moses Masiga Wetangula versus Moskari Kombo, your Lordship reiterated that double rule. They say if the election was conducted so badly that it was not substantially in accordance with the law as to elections, the election is vitiated, irrespective of what the result was. This case came to this court, and this court, this is a rectangular decision, did come to this court. This court did not deal directly with that issue, but in paragraph 137, this court said that Section 83 of the Elections Act empowers the election court to declare an election to be valid or invalid following an election petition on the basis of certain conditions. The court cannot appear to condone illegality in the election process. That's as far as this court went. So in the Wetangula case, the court did not take the case that there was one rule. Although it was still ambivalent as to whether there were one or two rules, the issue of the illegality and the effect of illegality on the electoral process was made clear. My Lord, I will be coming out later to other authorities on this matter. Maybe I could end up by quoting the judgment of Abdikaim Osman Mohammed by IABC. In this case, Your Lordship Chief Justice sat together with my lady Deputy Chief Justice, together with Justice of Appeal Mwera. And in paragraph 422, you said that, sorry, no, I'm quoting the paragraph of the submissions. In the quotation, you say that the Section 83 authorizes the notification of an election only if the irregularities committed in the conduct of the election violate the Constitution or affect the result of an election. So again, you restated the double rule. And I will be coming to other decisions on that point. But Lord, let me leave that for a while. But before I leave it, I would say that the reason why we vitiate this result when it contravenes the Constitution is because there must be a presumption that when something illegal is done, the results are negative. So if, for instance, under Section 83, one were to prove that somebody was bribed, according to the one rule, it would mean that you'd not only have to prove that the person was bribed, you'd also have to prove that that bribe worked. And my position is that the moment you prove that the person was bribed, it means then that there must be a presumption that the intended result did happen. If you prove that voters were being bribed, you can't then be required to come and say, to show whether the bribe worked on the voters. Once you prove that a bribery of voters took place, then that must be presumed to have affected the result of the election. And that will also become important when my lordships are dealing with the forms that have been filled in this, because they are forms that are being said to have been forged. Then would your lordship, once you confirm that a form had been forged, then still require that you go back and start tracing the effect of that illegality? And this is the absurdity, my lord, that I am saying would emanate from having a single rule under Section 83. But Lord, I want to deal with the issue of the standard of proof. And this court clearly indicated that the standard of proof in election petitions is an intermediate standard that lies somewhere between balance of proof, a balance of probabilities, and proof beyond reasonable doubt. Firstly, my lord, the absurdity of having an intermediate standard, and that is a position that is currently being held in several jurisdictions. But the absurdity of it is that the standard of proof then becomes something that you cannot measure, because then the standard moves from court to court, from judge to judge, because the intermediacy of this standard is dependent on how you view the seriousness of the charges, the evidence. There must be a standard that is clear to be told, clear to read, clear to understand, and that is the same from court to court and from judge to judge. And to therefore talk of an intermediate standard is to create a position in law that is indeterminate. And from one litigation to another, from one judge to another, from one allegation to another, no party, no lawyer would ever know until a ruling is delivered what was the actual standard. We do have today the balance of probability. And every lawyer knows that if your case is on a balance of probability, then you win on the preponderance of evidence. You know what it takes you if you're on a reasonable doubt. But what are you supposed to do when you're on an intermediate standard that is not stated and that can change anytime? Change according to the judge, according to the circumstances, according to the court. So, my lord, at the time the 2013 decision was being decided, there was already a change in the Commonwealth towards restricting the law to only two standards. That in civil cases, there will be a balance of probabilities, and in criminal cases, there will be proof beyond reasonable doubt, and that there would be no intermediate standard. And that came out in the decision that my learned friend had referred to. And in that decision, by the time the decision was being passed, I'll get the decision, my lord. Sorry, my lord, in a minute. Yes, my lord, this was a decision of the Privy Council on an appeal from the Court of Appeal of Mauritius. And it is in page 798 of the Authorities of the Petition, Volume 3. My lord, by the time that decision was being passed, the House of Lords had already passed a law that had been very emphatic about the standard of proof. And this was the case of rebuilt children, which was being followed by the Privy Council. My lord, in paragraph 198 of the decision of this 2013, this court did make a reference to the Privy Council decision. And you say, thus in Mauritius, Jagnuth versus Rigadu and others, the Judicial Committee of the Privy Council affirmed the decision of the Supreme Court of Mauritius, nullifying the election of the appellant. And the following passage occurs. And your lordships, it says, in the Jagnuth case, the court observed that election petitions are civil in nature and that the test should be a balance of probabilities. My lords did not make a reference then to the fact that the Jugnesh case was actually implementing a decision that had been made a few months earlier by the House of Lords. And in that decision of the House of Lords, the Lord Hoffman, who read the lead judgment, says, I think the time has come to say once and for all that there is only one standard, civil standard of proof, and that is proof that the fact in issue more probably occurred or not. And later on, Justice Baroness Hale of Richmond says, having concluded that the relevant proceedings are civil, in principle, it follows that the standard of proof ordinarily applicable in civil proceedings, that is, balance of probabilities, should apply. That decision was also followed by the Supreme Court of Canada. And this is the decision of FH versus Ian Hugh McDougall. And I will not go into that case, but that case followed what the House of Lords had said. In fact, was even more emphatic about the decision that in civil cases, it must be on a balance of probability. There have been other decisions that have followed that. There is a decision from the Constitutional Court of Seychelles. And again, it follows the House of Lords, it follows the Supreme Court of Canada. There is a decision of the Supreme Court in Ghana. I will give you the references, my lords.
Mr. Mwangi, I believe all those cases are on elections.
Yes, no, they are on different aspects, some even more serious than election. For instance, in Ribi children, a child had accused the parent of sexual abuse. And when it came to the House of Lords, the question was
which ones are on elections?
The?
Which ones are on elections?
That is, the Privy Council decision was on elections. There's also the decision of Nana Addo Dakwa versus Drama, which is in volume 1B of our list of authorities. But the point is that so long as the election court does not convict, then there is no need for the court to go to beyond reasonable doubt, because reasonable doubt is gone into when there are penal consequences. And in our law, even if the court were to think that an election court offense has been committed, the best that the court can do is refer the matter to the DPP. And it still behoves the DPP to investigate the issue and to bring up criminal proceedings if necessary. And it is in those proceedings under the Election Offences Act that you now have to prove the matter beyond reasonable doubt. But for purposes of deciding whether that malpractice is sufficient to invalidate an election, there is no legal reason why the court would raise the balance of proof to beyond reasonable doubt, because no judgment of the court can bring about any consequence to any person who is accused of having committed an electoral offense in the process of an election petition. So in settling the law regarding the standard of proof, the court must look into the reason why we go into the beyond reasonable doubt when dealing with particular accusations in elections. And that also comes out very strongly in the Canadian decision, that the reason we use beyond reasonable doubt is because in criminal proceedings, the law starts with a presumption of innocence, which is in the Constitution. And when you start off with a presumption of innocence on someone, then you have to do beyond reasonable doubt in criminal proceedings. But then says in civil proceedings, that is not the case. And therefore, that becomes unnecessary. My lords, on that basis, my lord, we will submit that your lordships must review the issue of standard of proof in election petitions and agree that, well, I apologize. We invite your lordships to review that decision and settle the law. And my submission, my lord, is we have given you a case from the House of Lords, a case from the Supreme Court of Canada, a case from the Constitutional Court of Seychelles, a case from the Constitutional Court in Ghana, a case from the Judicial Committee of the Privy Council, and we will invite you to find that these are more persuasive authorities than the authorities that this court relied on in the 2013 decision, the authorities from Nigeria.
Now you are not condemning the Constitutional Court of Seychelles.
The arguments that, all the arguments emanate from what was the view of law that was laid out in the House of Lords. And continuously, all courts that come into contact with that decision seem to agree that it is best position of law in respect to standard of proof in civil and criminal matters. And we will invite this court to follow suit as the rest of the Commonwealth is doing.
I say that because of the criticisms that have been leveled against Raira 13 because of a decision from Seychelles.
Most obliged. But I support it mostly because it follows law that we are able to trace back. My Lord, the other legal issue I wish to deal with is in respect of Article 81 and 86 of the Constitution. The law requires that elections must comply with those two articles. But in particular, my Lord, I want to mention, to deal with what are these principles that the Constitution is talking about. Because the Constitution says that an election must be accurate, verifiable, secure, accountable, and transparent. And we want to propose to you what would be the relevant definitions of these terms in respect of an election in Kenya. When one meets these terms, they are usually used in different contexts in other cases. I have not been able to trace a context in which these terms have been used in respect of an election. And these are the following propositions that we wish to invite the court into in terms of definition. Firstly, that when the Constitution says that an election must be accurate, that it means that the election results must be mathematically precise and competent. And that would mean that ballots were correctly counted, that results were properly tabulated, that the totals were totally calculated. It is a mathematical accuracy in respect of that election. Secondly, when the law says, Constitution says an election should be verifiable, our proposition is that it means that election must be supported by legal instruments that authenticate the results of that election. And this would mean that, for instance, that results have been recorded in the prescribed form, that that form has been properly executed, that it has been executed by the appropriate electoral officer, that it has been published in the appropriate media. And there have been instances, my Lord, in which courts in Kenya have invalidated election results on issue of verifiability. And my Lords will say that in this petition, verifiability is one of the major grounds on which the nullification of this election is sought. And we are saying that if you go back into the documents that are there, it is very difficult to verify this election because either the forms are not authenticated, as IEBC itself had said it will authenticate, or they are signed by the wrong people, or they are not on the appropriate prescribed form. And I will be coming to authorities on the issue of verifiability. In respect of the word secure, our proposition is that an election is secure if the election processes and materials are protected from manipulation and interference. And where election materials and data are also protected from manipulation, from loss, and from damage. My Lord, I think that is one of the issues that is going on in respect of the audit of the the data to find out whether this technological system was secure. Fourthly, my Lord, when we talk about an election being accountable, our proposition is that an election is accountable if it is capable of being scrutinized from its own records. So in the context of an election, for instance, the national tally must be able to be accounted for from the tally from the constituencies. And the constituency tally must be able to be authenticated by the polling station tally. And the polling station tally itself must be able to be accounted for by the ballots. And this is a second issue on which this nullification of this election is also sought. That this election is such that it is become very difficult to scrutinize this election on the basis of its own records, which is the submission that had been made earlier this morning. And lastly, our proposition on the word transparent is that an election is transparent when its processes are open and easily accessible for observers and the public. This would include the admission of agents into all centers, open announcements of results, open display. And in this respect, I'll come back to the issue of the public portal and the importance that that public portal played in respect of the transparency of the election. My Lords, in respect of security, there is an issue that we would want this court to consider, that at the time when IEBC was, in the petitioner supporting affidavit volume 2, my Lords, on page 64, there is a letter written to IEBC by the Communications Authority of Kenya, and it says that we note that you have proposed the use of a private cloud to supplement your primary and disaster recovery sites. Given the sensitivity of your statements, we recommend that a private cloud should not be hosted on infrastructure that is shared with other third-party users, as this would compromise the security of your system and the systems of third-party providers. It says, further, we recommend that the cloud service is hosted within Kenya so that any issues arising from a cyber event are handled using Kenyan laws. In page, that was page 64. In page 62, this letter was sent on the 3rd of January. In the 5th of January, IEBC refuses to follow that advice of CCK, and in fact, now writes to SOFOMOFO and allows them to have a private cloud of all their data. That is a consideration we'll ask the court to make, again, subject to the findings of the audit that is going on in respect of the security, that IEBC deliberately ignored the security advice given by the Communications Commission of Kenya and went to host its cloud on a place where there were third-party users against the advice. My lords, I now want to look at the issue of the effect of non-compliance. Before I do that, my lord, I had authorities on the issue of verifiability. I'll ask your lordship to look at the case of William Kabogo. And this relevant, this is a case from the Court of Appeal in which the court dealt with the issue of verifiability. I'll also ask the court to look at the case of Omino Magara. In this case, particularly, I want to take a relevant paragraph, my lord, but again, this was the nullification of another election on the issue that the results were not verifiable. And lastly, in the case of Abdi Kaim, which I had quoted earlier, again, an election was nullified on the basis that it was not verifiable. But look, before I leave that point, before I go to the point of effect of non-compliance, I want to deal with the case of Minor KI versus IEBC. Because this case is being relied on as a response to the fact that this election was called when most of the documents had not arrived in the National Tallying Center. My lord, my position is that when Minor KI was passed, the idea was not to excuse the chairman from the duty to verify. What Minor KI did was take away from the chairman the power to alter any results. But IEBC seems to have taken that as a license by which they could now abdicate their authority. And that is the excuse they give for calling the election, despite that they did not have almost 11,000 Form 34s. Although there is no explanation as to where 187 Form 30Bs were, even at the time they were calling the election. But I will ask the court to look at page 36 of the judgment of Minor KI. And in the paragraphs, in the third and fourth and fifth paragraph, it says, of course, before he makes the declaration, his role is to accurately tally all the results exactly as received from 290 returning officers countrywide, without adding, subtracting, multiplying any number, but it says contained in the two forms. Even in Minor KI, the contemplation was that when the chairman of the IEBC receives Form 34B, it must be accompanied by its Form 34As. And that he would not, as is being preferred, he could not ignore the fact that Form 34B had to be supported by a Form 34A. Then the other paragraph that I will ask the court to look at is in page 38. Again, and again the court said the appellant, as opposed to its chairperson, upon receipt of prescribed forms containing tabulated results for election of the president, electronically transmitted to 8 from the 40,000 polling station, is required to tally and verify the result received at the National Tallying Center without interfering with the figures. So there was an anticipation, even in Minor KI, an expectation that it is the duty of the chairman to ensure that he has all the forms before he calls the election, and did not require him, as it now purports to say, that he was supposed to ignore the fact that Form 34 existed. And in the annexures we have, Your Lordship will see that even in the contemplation of IEBC, they knew that Form 34s would have to first arrive to the constituency before a Form 34B is filled. And that then all the documents would then arrive to the National Tallying Center before Form 34 is also filled. So, my lords, on that note, we would ask you not to accept an explanation that the case of Minor Kiai in any way took away the duty of IEBC to ensure that it had all the documentation at the time that it called elections, or for your lordships to let the case of Minor Kiai be an excuse of the chairman to abdicate his authority and call an election before he has all the relevant documents. My lords, the last I wish to mention on what the effect of non-compliance would be, and I had relied on authorities passed previously by my Lord Chief Justice and my Lord Deputy Chief Justice, my lady, the Deputy Chief Justice. I wish to use a case Justice Renawala passed as a High Court judge as he then was, in Masaka versus Khalwale, which was also very emphatic about the results of non-compliance. I think that case had also been quoted earlier. And in that case, my Lord also was very emphatic that the result of failure to observe the principles of an election, the effect is to vitiate the result. And that is properly in line with what we have now as Section 2 of the Constitution. My lords, for that reason, it is my submission that according to the law, we have been able to lay the basis for the dismissal of this election. But one issue still remains, respecting the considerations, whether there are any considerations outside the law that an election court should have in reaching a decision to vitiate an election. And my Lord, this is my submission that one of the mistakes made about elections is that elections are looked at as a political exercise. And it is my submission that elections are actually a legal exercise. There is nothing intrinsic about human nature to have elections. In fact, if one were to believe the philosopher Thomas Hobbes, what would believe is that the essential nature of human beings is to intimidate each other, is to rule over one another. And elections are part of our social organization to stop that. And therefore, it is the law that requires us to have elections. And if you look at everything about election, most of it is legal. It is elections, it is the law that says who is a candidate. It's the law that says who qualifies to vote. It's the law that says how you will vote. Just about everything in an election is legal. So, and I'm saying this because the invitation that would be made to this court is to look at the political question. And usually that is where it says, no, look at the numbers. And we are saying you must look at how those numbers arose. And that unfortunately, was an effect of 2013, that by misinterpreting Section 83, the invitation then that is made regarding elections is just make sure that the petitioner can never overcome the numbers. And my submission is then that the lead extended from 8,400 in 2013 to 1.5 million in 2017. And if the question was that you can do anything so long as you display numbers that are difficult to offset, then elections become a purely political issue rather than legal. My lords, this matter of the politics of an election also did come up before this court in 2013, but the court was not very clear regarding the position it would take. But it seemed, and this is in the guiding principles that were laid out in that case. And the court in the guiding principles took a lot of observation regarding the political nature of elections. And the court said that this is the first test of the scope of the Supreme Court to administer law and justice in relation to a political will, the election of the president. And it says, this judgment, therefore, may be viewed as a baseline for the Supreme Court perception of matters political, as this interplay with the progressive terms of the new constitution. But later, when invited to exercise judicial restraint, the court refused to exercise judicial restraint and insisted that the court had a role to play in matters of election as a purely legal matter. So the court was quite ambivalent regarding that issue. I'm trying to state a discussion the Lord Chief Justice has had about the political nature of elections. And your Lordship did assert more of the legal nature of an election, and that one must look purely into whether the law has been followed and whether the legal principles have been satisfied when you come to judging an election. And on that basis, one must ignore whatever the political consequences of vitiating an election is. And we all live in this society. The temptation would be, what would that mean? Does that mean now we'll have another round of campaigns, we'll have another round of elections? And I am saying that as a purely legal matter, one must state the law as it is, regardless of what the political consequences of that pronunciation is. I think that would be the right position, and on that basis, I let my learned Mwalim also continue. Thank you.
My Lord Chief Justice and other members of the bench, I would like to pick up from where my learned friend left. Yes.
Before you do that, he call you Mwalimu?
Thank you.
Which you are.
Yes.
The sugars are going low.
Yes.
And I'm sure that applies to everyone. Can we have a lunch break? And then come back, you have your 1 hour.
Thank you.
You have your 1 hour. And as I had requested, please don't aim at exhausting the entire period I give you. If you can do it faster, it will help us so that we move on. We will adjourn and come back at 3:30. Thank you.
Attorney General
Yes,
of the Republic.
of Kenya.
How are you?
As I am very hungry.
We are now not too far to go. I don't have no idea where we are right.